Hello, my name is Hugh Patterson, and I'm a scholar at the University of North Texas and at the University of Oregon. My talk today is part of the 27th Southeast Asia Pacific Audiovisual Archive Association Conference, and the title is A Step Beyond Copyright, Considering Thailand's Privacy Law as it Applies to Scholarly Video Resources. I'm talking about this in contrast to copyright, as the general call in the conference included copyright, but the focus of this talk is on Thailand's new privacy law and the potential applications that archivists and scholars need to consider as they use the medium in their research. So, as a general disclaimer, I am not a lawyer, so this is not legal advice. But as managers and archivists, and I've worked with ethnographic and ethno-linguistic collections in archives, so that is part of my background, and my scholarly research relates to copyright and international context of copyright and privacy laws as they relate to archives and archivists. One of the interesting things about new law is that often we don't know what it means until a judge actually starts making rulings in cases brought before in the court. Many times we have the text of the law, but the nuance of how it will be applied is still unknown. The Thai law, the new law in Thailand, the Personal Data Protection Act 2562, was approved in 2019 and went into effect last year in 2022. So in the scholarly context that I work in, let me just describe this a little bit. I mentioned that I've worked in language documentation or in linguistics where video is used. I've worked in contexts where ethnographic materials are produced as part of research projects, and the scholarly resources that I help facilitate and archive are often produced in this sort of context. And in this context, this is how video is often used. A scholar will partner with a community of some type, and there will be storytellers or people who participate in the research. The scholar may be the person behind the camera, or might be another member of the community that's behind the camera and operating the video making device. And these resources then are often annotated, transcribed, and brought to an archive and put there for preservation and access, community access, and broader access. The archive then takes a role in the preservation and stewardship of the resources, and may engage third-party services to work with those resources and enrich those resources, reuse those resources. Broadly construed, these many people who engage in this activity with scholars from the community side want their resources widely distributed. There are exceptions, but broadly, in my experience, the people are happy to share about their language and their culture. To kind of put some face to this, the storyteller put some institutional face to this. The storyteller might engage with a scholar who is also employed by a university and a representative, therefore, of the university legally in a legal way. The archive is its own institution, and the third-party service may be something like YouTube, where the archive loads videos to YouTube so that wide distributed audiences can engage with them. In a legal context, the way that the parties of the privacy laws are distributed in here would be that the storyteller would be the data subject, and the scholar is the data controller, And the archive is the data processor, or the university is the data controller, depending on how we look at the situation. And then the third-party services would be doing data processing on behalf of another data processor. Now, before we look at some of the details of the new Thai law, let's take a look at some concepts. I just want to acknowledge that privacy as a term means a lot of things to a lot of different people. It means a lot of different things. And it can be applied in many ways. And as archivists, we struggle and meet different community needs in different ways as it relates to privacy. So privacy in one context can mean freedom from something, but in another context, it can mean freedom to do something. It can mean freedom in a personal zone. It can be freedom in a public zone. It could be behavioral privacy, to be able to act and behave in a certain way without the concern of others. It could be privacy to be able to conduct my own body or an individual's own body in a particular way. But when it comes to law, oftentimes we think, oh, that just relates to when it's on the computer. Well, some of these laws, like the GDPR or Thailand privacy law, are written in generic ways that don't necessarily just restrict to digital contexts. And there may be applications outside of those digital contexts. Thailand's new law specifically is interesting for a couple of reasons. One of those is that it's extraterritorial. So it's been compared to the GDPR, which is the General Data Protection Law of the European Union. And both laws are extraterritorial and are tied to citizenship and to the location of the interaction. So, but Thailand's law shouldn't be considered the same as the GDPR. It has some very significant differences as well. So as archive managers that might be working at a global scale, we need to be aware of these different data handling requirements and appropriately engage with them. So one of the very interesting things about this new law is that personal data is widely construed. Personal data means information relating to a person which enables the identification of such a person, whether directly or indirectly, but not including the information of deceased persons in particular. So this generally just it's not limited to an IP address. It's not limited to video. It's not limited to a name or a special number used for identification purposes on identification documents. It could be somebody's voice print or their iris print or their fingerprint. So there's a lot of different ways that a person can be identified, and the law is written very broadly. It doesn't apply to persons who have passed away or are deceased. And in this way, it can be contrasted with copyright. So it's not a right that gets passed down into another generation in the same way that copyright can be. So a data controller, as we saw before, would, talking about scholars, they can't collect or disclose personal data unless the data subject, the person being videotaped or recorded, has given consent prior or at the time of such collection. And that permission needs to be made in a written statement or an electronic means, unless it can be done. It can't be done by its nature. The data subject may withdraw their consent at any time. And this makes it a challenge for dealing with the scientific record or the cultural heritage record And at what point does a preservation institution deaccession their materials is a challenging question that we as archivists must deal with. The collection of personal data shall be limited to the extent necessary in relation to the lawful purpose of the data controller. So this speaks to the specificity that scholars need to write into their permission statements. The rights of the data subject are to obtain a copy, to erase and destroy, and restrict the use of personal data. So these permissions or rights to do these things, this is not all of them. The full law is like 39 pages. But the rights there can be changed, or the agreement can be changed after the initial agreement. So this means that scholars might need to be engaged with their data over a longer period of time, or be prepared to, or have the support and infrastructure and the tools to do that. The data controller then has the duties to have a system for erasure and destruction of data, and notify the Thai office that oversees the law if there is a data breach and there's a type of access that was not originally designed. So when that happens, how that happens is beyond today's discussion, but there are some interesting exemptions. I want to quickly just touch on these just really quickly, that can possibly apply to cultural heritage contexts. If the materials or document are produced for the achievement purpose of relating to the preparation of historical documents or the archives for public interest. Now, as far as I know, the definition of public interest may be broad, but it's not clear from the definitions inside of the document. Now, I'm working with an English translation, and it's an unofficial translation, but and perhaps maybe in the Thai, the one written in Thai language, it's more specific, or it has some legal nuance that I'm not picking up in the translation. But for the purpose of relating to research or statistics in which suitable measures to safeguard this data subject's rights and freedoms are put into place in accordance with the notification prescribed by the committee. So this seems to indicate that there may be some extra guidance coming from the committee at some future point in time that we're not aware of yet, or at least I'm not aware of. So there are some exemptions then, and number 2, for preventing or suppressing the danger to a person's life, body, and health. Oftentimes, we could think of the materials that we produce as providing a healthy relationship for the people for flourishing in their language, especially in the context of endangered languages, where the working with a community to build up their language and support them in their language goals is actually supporting their community. And so it's bringing health and vitality to their community. A very interesting exemption in here for sharing personal information is that actually sharing the personal information is required in the process of executing a contract around that information. And so the examples I've heard is, well, a personal information might be some information like an address on a letter, but the postmaster or UPS or the person delivering the letter must use that personal information to perform their services to deliver the information, the letter? Well, it's kind of, in one way, Creative Commons licenses are like this, right? So Creative Commons licenses are applied to a material by the owner, and if the data subject is also the owner, and they're licensing that, then the archive is then given the permission to distribute that according to the Creative Commons license. And so, and almost a mandate to also redistribute under certain versions of those Creative Commons licenses. So it's potentially there that if under certain circumstances, it would be implied that sharing that information would be part of a copyright license. But I'm not saying that's a fact. Then there's also certain exemptions, which I'll touch on here in a minute, for nonprofits and foundations. And we see this type of exemption in US privacy laws too at the state level. So one of the things here in this Thai law is that when these nonprofit bodies are making these resources and taking personal information, it doesn't, our archives are often structured as nonprofit bodies in the United States. And I assume this is maybe the case in other parts of the world as well. But when an archive as a nonprofit body takes materials and delivers those interpersonally, or those personal data more broadly, then the law says they can use it within their purposes. But if the purpose is to share that more widely, I'm not quite sure if it's inside the law's scope or outside of the law's scope. And so there might be some reason for clarity in this part. But there also may be some legitimate, shall we say, wiggle room for archives to do their designed purpose here. So this is going to be an interesting area to watch to see how it further develops. I mentioned the copyright component. So this is an illustration of the way it would work, is that the copyright holder would be on the storyteller, and they license it, and then the other recipients, because it's licensed, are able to do something with it. And it works if the copyright holder is the storyteller. It might not work as clearly when the copyright holder is the university or the scholar, the data controller. So in conclusion, I just want to say that privacy consent is moving forward, is very important to document, along with the resources that are created by scholars in Thai contexts or working with Thai nationals outside of Thailand even. Production roles in the video of those resources are going to be important, and archives must have a deaccession process for content not licensed by the data subject. So thank you very much, and anticipate your questions.